The victim, Melinda Pleskovic, just 49 years old, was savagely murdered by you, Mr. Scullin, in the kitchen of her home, which she had generously made your home. You shot her 3 times and stabbed her a minimum of 35 times. You did so while her son, Kyle, who has Down syndrome, must have been or was in the home. You did so with your own daughter and her granddaughter, Aurora, close by. Then you had the audacity to sit down for dinner with her husband, Bruce, at Applebee's, where their daughter, Anna, worked. Then you returned to the scene of your vicious crime and allowed Bruce to go into the home that he shared with his wife and children and find his wife on the kitchen floor in a pool of blood. You served as a pallbearer at Melinda Pleskovic's funeral, knowing that you were the person responsible for inflicting upon her loved ones and many friends all of the pain, shock, sorrow, and heartache they were experiencing and continue to experience a year after you murdered her. Melinda, or Mel, as she was known to many, was the beloved wife of Bruce, mother to 3 children, Megan, Anna, and Kyle, and the grandmother of your own daughter, Aurora. She was a teacher for 27 years and a family member, colleague, friend, and matriarch or mom of what I understand was an extended soccer family. I did receive 51 victim impact statements, to include those from her husband, her 2 daughters, sister, brother, nephew, great-nephew, mother-in-law, brother-in-laws, nieces, her second parents as they were known, colleagues, friends, soccer friends, and students' parents. I read each and every one of those letters, and the words used to describe Mel include, and I've taken these directly from those letters: awesome teacher, amazing friend, the rock that held her family together, very special, fun, selfless, beautiful with a caring spirit, an inspiration to others, smiling and welcoming, a natural with kids, the most inclusive person, always welcoming, a coach, a role model, had an infectious laugh, no contest. Of course, that's hurt the family because there's no true acknowledgement or remorse that you've displayed at this point in time. But again, I understand that you have legal rights and are reserving those rights. So I cannot, by law, technically hold that against you at this juncture. But again, based upon the letters that I've read, you've not shown any remorse to anyone throughout this process. And again, as explained to me in those letters, Mel's family and friends who had the opportunity to speak with you and watch you in the days following her murder, to include at her funeral, find your actions and attitude after you murdered her to be incomprehensible and abhorrent. And what I think so tragic is that Mel's son Kyle does not understand where she is and continues to look for his mom every day. That is so sad. And you did that. Therefore, on the aggravated murder count 1 that you pled guilty to, the court imposes a sentence of life imprisonment with the possibility of parole after 30 years. The 3-year firearm specification, or the 3 years for that firearm specification, must be served prior to and consecutive to that term, meaning that you will not be eligible for parole until you have served 33 years. With regard to count 5, tampering with evidence, that's the felony of the 3rd degree. The court is imposing a prison term of 36 months on that count. With regard to count 6, making false alarms, the misdemeanor of the 1st degree, the court is imposing a period of local incarceration of 180 days. And with regard to count 7, endangering children, again a misdemeanor of the 1st degree, the court is imposing a period of local incarceration of 180 days. Now, those 2 misdemeanor offenses, the time imposed there must be served concurrent with the time imposed on the aggravated murder. And with regard to the tampering with evidence, the court is imposing that concurrently as well. I know the state's offered a basis for the court to impose consecutive time, but I'm not sure that, I think the only possible basis would be under Section B, and I'm not sure that that would, the circumstances surrounding this particular case would warrant consecutive time based upon that portion of the statute, because there are separate findings, as the state pointed out, that I must find, and I think it would be difficult to find that one of those required sections actually applies. So, now, with regard to count 5, though, the tampering with evidence, as part of your sentence, you are subject upon your release from prison to a period of post-release control to be supervised by the adult parole authority. This would be optional on the part of the adult parole authority and could be for up to 3 years. If you would fail to meet the terms and conditions of any post-release control supervision imposed on you for count 5, then the adult parole authority could modify and or extend your supervision and make it more restrictive, incarcerate you for up to 1/2 of the original sentence imposed by the court, charge you with a new offense called escape, another felony where you would face additional prison time, and if you commit a new crime while on post-release control, you can face the maximum penalties under the law for the new crime committed. There's no restitution that was part of the plea or that's been documented or demonstrated. I'm not imposing a fine. I am ordering that you pay court costs, and credit will be granted for all days spent in custody, in this case prior to sentencing, together with all future custody days while the defendant awaits transportation.
363 days.
You'll be getting credit for 363 days. Is there anything further on behalf of the state?
Nothing on behalf of the state.
Anything further on behalf of the defendant?
No, Your Honor, thank you.
Appellate rights?
If the court wishes.
You wanted me to read those to him previously, correct? At the time of the plea?
Certainly.
All right. Do you understand, Mr. Scullin, that you have the right to an appeal in this matter within 30 days after the filing of the court sentencing entry?
Yes.
And you understand that if you are unable to pay for the cost of the transcript, the record, and all relevant documents required for the appeal, that they would be provided without cost to you?
Yes.
And you understand that if you are unable to pay for an appeal, you are entitled to have a notice of appeal filed without the payment of a filing fee?
Yes.
And you understand that if you are unable to obtain counsel for an appeal, counsel will be appointed for you at no cost?
Yes.
All right. Anything further, Mr. Getatus?
No, Your Honor, thank you.
All right.